M.K. McKinney, his father, Dr. Michael McKinney, and Josh Mullins, the three men charged in connection with the 2023 murder of Amber Spradlin, appeared in court today. A motion was on the table to decrease the bond currently set for M.K., who is charged with 8 counts of complicity to tamper with physical evidence and murder. And status hearings were held for M.K. and the other men, each charged with those 8 tampering counts. M.K.'s attorney argues he should be released while more evidence and DNA is processed, while the Commonwealth claims he is a danger if allowed out on bond.
We've got a defendant here who's presumed innocent, who may be sitting in jail while we wait. It's already been a year to get test results back, another year to get information back.
We think that there is ample evidence to demonstrate that he is unstable and dangerous.
Judge Eddie Coleman says he will rule on the bond reduction motion by Monday.
Hope you like it, Big Bubba. You gonna get what's coming to you. You son of a...
Dr. McKinney, this is WLEX. Is there anything you have to say about being indicted by a grand jury a little while ago?
You're not getting out of this, buddy. You're not above the law.
Dr. McKinney, is there anything you'd like to say?
That's what I think, but I don't know.
Huge news out of Prestonsburg, Kentucky. They've made some arrests on the Amber Spradlin case, and for those of you that don't know what that is, it was a brutal unaliving that happened in Prestonsburg to Amber, and my condolences, but it's awesome news that we got today. This just goes to show you that when the people don't remain quiet and they keep vocal about it, we can make stuff happen. I really don't think there would have been much come of this case if we hadn't had people voicing all of their opinions about this matter. A lot of influencers from the area and all over the country had done updates on this case, and I really just want to say thank you to everyone that has helped us out in Kentucky and defeat corruption in small towns. Y'all search Amber Spradlin in the search bar and you'll see a bunch of stuff about it if you want any more information. Love you guys. God bless.
I thought this day would never come. I've just been in such anticipation for it, and it's just, I had chill bumps all day yesterday, and everybody said, I bet you'll sleep good, but I didn't sleep good last night because I was so pumped up and hyped up from it all that I just couldn't wind down. Yesterday was really exciting.
The courthouse was packed as M.K. McKinney, Michael McKinney, and Josh Mullins had their bonds set. M.K. McKinney, who is charged with murdering Amber Spradlin, had his bond set at $5 million full cash. His father, Michael McKinney, suspected of tampering with evidence, had his bond set at $250,000 full cash. And Mullins, who is also suspected of tampering with evidence, had his bond set at $100,000 full cash. All 3 men are considered flight risk and will be subjected to GPS tracking in the event they meet their bonds. Both of the McKinneys are also considered a danger to themselves and others.
Well, the community support has been awesome. It's just overwhelming. It's helped keep us going, and everybody's so invested in this, and I think it's a really good thing because I think we can start to see some change. If we keep pushing forward, we can see some change in things around here.
A prominent dentist is among 3 men arrested in connection with the murder of a Kentucky woman. The murder happened a year ago. Amber Spradlin was found stabbed to death inside of a home in Floyd County, Kentucky in June of 2023. The house belongs to Dr. Michael McKinney. His son, Michael McKinney III, is charged with Amber's murder, as well as 7 counts of complicity to tamper with evidence. Now, Dr. McKinney and family friend Josh Mullins are also charged with complicity and tampering with evidence. They're accused of trying to cover up the crime. Now, Amber's cousin believes that Amber helped solve her own murder.
It means to me that she fought. It means to me that her last few minutes of her life were sheer terror with a monster on top of her stabbing and stabbing. I'm sure that she was yelling, and I know that she fought, and it's just it's horrific, and there really is no justice in this type of thing, but this is the best we can do.
Now, Michael McKinney Sr., the dentist, has since bonded out, but he's on house arrest awaiting trial. We're asking the question this morning, did the cover-up draw attention to the crime? Let's bring in our guest now and talk about this. Criminal defense attorney and former district attorney Matthew Mangino, criminal defense attorney and former prosecutor David Bruno, and retired DEA supervisory special agent Michael T. Wilhite Sr. David Bruno, would you start us off here, please? Your thoughts?
Wow, fascinating case. I mean, I've walked crime scenes, stabbings, and they are brutal, with blood spatter on the ceilings and the walls, and I could only imagine this crime scene. But when they got there, they had a problem because these three, they worked together to destroy the camera, the surveillance video, the computer, the knife, the clothes, all the blood was covered up. So they had a big dilemma. And what I would imagine too, and we're learning more as this unfolds, is that they probably all lawyered up as well, which gave them a real problem as to the identity of the killer. Because that's really the only fact pattern that makes sense to me as to why it took over a year to bring these charges. But look, now you have a son who allegedly committed the murder, a dad who allegedly covered it up, and then there's that friend. And I think the prosecutor's probably trying to use the friend at this point because he's the loose link in that chain to bring breath to the incident in the house because all the surveillance videos have been destroyed.
Great points, David. Yeah, this is bad. You wonder if the cover-up got these guys caught. Michael Wilhite, to you next, please. Your thoughts.
David hit the nail right on the head. But let me add this: the cover-up started with the father and the son conspiring to do that. I think it was a false or a crafted 911 call that just wasn't followed up on. Looking at the footage and looking at reading the background, apparently, I guess the son called 911 when the incident happened, gave some false information. The dad at some point calls interferes with that call and to give some other information. Dispatch doesn't deploy or send out dispatch a patrolman, a police officer to that location at all. So that conspiracy to influence the investigation or tamper with the investigation started way before started then.
Right, Michael. The state police in Kentucky had said that they had a suspect initially during the first week of this investigation, but it took so much time apparently to go through the blood evidence and build this case. Now, oh my, does it seem like they have a solid case to you? Matthew Mangino, talk to us here, please. The allegations of a cover-up and these terrible allegations regarding the death of this woman, your thoughts?
Well, Julie, the cover-up probably, set law enforcement behind because, obviously if there was videotape that would have been available and things like that, this issue gets wrapped up very quickly. So the cover-up has delayed the investigation. But what authorities want to do is they want to make sure that, so to speak, they have their ducks in a row before they file charges. You don't want to file charges prematurely, even if you have a strong suspicion of who's responsible and how this occurred. You want to make sure that all the evidence that you have lines up with what the theory of the case is. And in here, I think they were very meticulous. They were very patient. They waited until they were sure that they had the evidence that they needed to move forward to prove this person guilty beyond a reasonable doubt, and then to take care of the others who delayed this process by covering it up. So I think the prosecution waited till they were in a strong position to move forward and file charges in this case.
Right, Matthew. They had to just take the time, go through everything methodically. This cover-up seems so elaborate.
Cousin to Amber Spradlin visited the Floyd County Fiscal Court meeting this morning to speak about some recent phone calls and what she calls accusations. We have more from the courtroom.
Hall was first to speak during the public comment and immediately made her intentions clear.
including defending herself against rumors that she made plans during the call.
About 4 months ago, I received a phone call from an individual in the jail asking me to loan them money to bail out of jail with. I turned them down on their request, and I jokingly told them that they just needed to stay in jail where they belonged because MK would be there soon. And I chuckled and I got off the phone. There were no other phone calls. There was no exchange of money. This was not a murder for hire plot, as you have been telling people in the community.
Judge Williams denies the involvement for which he has been accused and suggests that Hall should offer the tape for the public to hear.
I didn't make that call. She's the one that made the call. The call needs to be played publicly and let folks hear it. The call was given to me. It was not given through the county jail. The jailer did not give it to me. Once I did receive a copy of the call, I did an open records request a copy to verify the validity. But I did not release that tape.
Mountaintop News obtained a copy of the recording. Only one section includes any reference to the case.
I was kind of hoping you'd stay in there till they got MK in there.
Till they got what?
MK in there.
I know. Well, I mean, I can come back fast.
Okay. Yeah.
But there was more on Hall's mind than just the phone call during the court session.
Only in eastern Kentucky would the Floyd County Judge Executive be trying so hard to make a murder victim's family member look like a criminal. It's clear what side you take in the matter. You played the 911 calls for people in the community when the KSP didn't want them released. You intercepted a letter meant for the Attorney General and used it as an excuse to request a special prosecutor without consulting with the family. And now you're spreading false allegations in the community regarding my character. I've been a respected physician in Floyd County for nearly 30 years, and because of your false allegations, my reputation has been damaged.
Of Amber Spradlin and son of prominent Eastern Kentucky dentist, Dr. Mike McKinney. He appeared in court today, and he brought the big guns with him. By big guns, I mean highly acclaimed Kentucky criminal defense attorney Steve Romines out of Louisville. Romines asked the court to lower the $5 million full cash bond that is currently holding his client, and instead proposed that the court release MK McKinney on a $1 million property bond based on MK McKinney's very low pretrial risk assessment score. So what is a pretrial risk assessment score? Every criminal defendant in Kentucky, upon being booked into the county jail, will have to sit for what we call a pretrial interview with a pretrial officer. That pretrial officer gathers all sorts of background information about that defendant. Where are they from? Where do they live now? How long have they lived there? What's their educational background? What's their work history, their criminal history? What kind of ties do they have to the community? Do they have substance abuse issues, mental health issues? All of this information is compiled together, entered into this computer program, and then the computer program generates a number, and we call that number this defendant's pretrial score. Pretrial risk assessment score. The point of a pretrial score is to help judges determine what kind of bond they want to set for this particular defendant. Because the whole point of bond is to ensure that the defendant, if you let him out of jail, will continue to show up for their court dates until the case is resolved. The lower the pretrial score, the lower the bond is supposed to be. In most cases, where it's a very, very low pretrial score, the law encourages judges to release these defendants on their own recognizance. Let them just sign themselves out of the jail and go to the house. It would appear as though the only blemish on 24-year-old MK McKinney's record is one speeding ticket for driving 5 miles over, giving MK McKinney a very low pretrial score. Based on that very low pretrial score, attorney Steve Romines argued to the court that MK McKinney should be granted a far more reasonable bond than $5 million full cash. Steve Romines even points out that based on MK's low pretrial score, he has every right to come in there and ask the judge to release MK on his own recognizance, let him sign himself out of the jail and go to the house. Of course, Steve Romines does not do that because Steve Romines has a lick of sense and this ain't his first day at the courthouse rodeo. Romines further argues that not only is his client entitled to a substantial bond reduction based on his low pretrial scores, but also that because there is so much evidence pending out there awaiting lab testing that's going to take at least another year, it essentially violates his client's constitutional rights to have to sit in jail for a solid year on a $5 million full cash bond, waiting for the state to do its job. He says the state's inability to do their job quickly and efficiently shouldn't prejudice the defendant. Now, that's a fair point. Lastly, Romines argues that basically the evidence collected against MK thus far in this case is tenuous and thereby not sufficient to justify a $5 million full cash bond. On the other side of the courtroom, you have Commonwealth Attorney Brent Turner, the prosecutor in this case, who strenuously objects to the court reducing MK's bond by even $1 at this point. Brent Turner points out correctly that the statute does not require the judge to substantially lower MK's bond based on his low pretrial score, but only requires the judge to consider doing so. Brent Turner argues that MK's low pretrial score is basically meaningless in light of the serious, dangerous nature of the offenses for which he is charged. Amber Spradlin was brutally murdered, stabbed 11 times. The knife was broken off in her head for what appears to be no motive other than pure evil. That, of course, raises the question of what role mental illness could have played in this senseless killing. Brent Turner points out that he has obtained evidence, statements from individuals who know MK, claiming that MK has acknowledged himself that he sometimes hears what he calls dark voices and that those dark voices at times overpower him. Brent Turner, of course, uses this to bolster his argument that it is too dangerous to release MK into society on bond at this point. That pretty much sums up the arguments on both sides. One argument that I did not hear from either side, which is also a factor the judge must consider in making bond determinations, is the financial resources of the defendant. The McKinney's pockets are some of the deepest pockets in Floyd County. In order for judges to set bonds fairly across the board, they have to consider the defendant's financial resources. The crux of Steve Romines' bond argument was that a $5 million full cash bond was excessive in this case. But was it? For the indigent defendants I used to represent as a public defender, defendants who could not afford to hire an attorney, $5 million full cash was always going to be excessive for them. Shoot, sometimes $500 full cash was excessive for them. They didn't even have shallow pockets. They had no pockets. The truth is, it may make the McKinneys uncomfortable to post a $5 million cash bond, but they could probably pull it off. Whereas many of my former clients, if their life depended on it, could not post a $500 cash bond. Make no mistake, there is one justice system for the haves and another justice system for the have-nots. And every time a court fails to take into consideration that particular defendant's financial resources, the injustice of that dichotomy is further perpetuated. But I digress. Ultimately, in this case, the judge decided to take MK's request for a bond reduction under advisement, and I believe he suggested he would try to get a decision out tomorrow. So, what do you think? Based on these arguments, should the judge let MK out of jail this weekend?